Okay, so welcome everybody to the fifth workshop of this Marco Biagi conference. My name is Edoardo. The speakers are already here. I would like to just introduce briefly this panel, and then we have a very tight schedule, so I must be very hard in cutting your presentation. I'm sure there will be no need of doing it. I know you all well, so you are serious people. This session, this workshop, gather together 4 papers on social protection and regulatory policies for autonomous work in a comparative perspective. Even though 3 out of 4 speakers are Italian, I can assure you, and if you read the paper, you know it, the comparative perspective is there. And I very much appreciated all the papers because they provide us a very clear perspective, both from the point of view of the problematic issues that are linked to social protection of autonomous work, and both because they also make some proposal in order to overcome or to tackle at least these problems and to try to find a solution which will fill the gap in a way between employment and self-employment as far as social protection is concerned. I think that this is a very important perspective, that one also of enlarging, extending the scope of application of labor law in a new dimension. So without any separation. Of course, the distinctions are there, but the separation of self-employment from employment, in my view, is totally outdated. And I am sure that in such a perspective, the panelists will help us in understanding how and to which extent such an inclusive view of social protection as I think an irrenounceable part of labor studies, if not of labor law, can help. As you will see, the perspectives are different, but we decided to put the papers together because there is a common understanding of the new perspective we should adopt in dealing with self-employment from the point of view of social protection. The problems are slightly different from employment, even if, of course, a link can be found in the way the social protection systems are organized, and the fact that even if more or less recently they have tried to insert self-employed, the technical instruments, the legal framework is often very uncertain as far as these differences are concerned. Even the framework in which the need is understood has been uncertain and different. But as you will see also from this point of view, all the panelists will provide us with very interesting insights. So I will give the floor immediately to Veronica Papa, University of Catania, Italy, the new working poor class. So Veronica, the floor is yours, 10 minutes.
But can you both hear me and see me? Because someone is telling me, yeah, you can. Thank you very much. So I'm trying to share my presentation, but it's not working till now. Okay. As the title of my paper suggests, the paper aims to deal with the intersections between self-employment and in-work poverty, and with the possible answers in terms of relative options at EU level. But before attempting an analysis of this theme, it's worthwhile making some preliminary remarks. First, the fight against in-work poverty is part of the broader strategy of the Union to fight poverty and social exclusion, and so far, European policies in this field stayed at the level of soft governance initiatives or soft law principles, starting from the Lisbon strategy, then continued with the social OMC and the Europe 2020 strategy, and more recently with the proclamation of the European Pillar of Social Rights, which refers explicitly and for the first time to the need of preventing in-work poverty. And second, self-employment is a highly polysemic concept that defines a very heterogeneous segment of the workforce, and in this sense, the line of research adopted in the paper is situated in the context of studies on self-employment as the ultimate form of precarity, as a result of a series of intersecting trends, and in particular of the increasing share of solo self-employed and of involuntary self-employed, and the high exposure of self-employed to the in-work poverty risk that is more than doubled, according to Eurostat, in comparison to the one of full-time employees. And of course, this risk is naturally destined to be expanded by the COVID-19 crisis. So given the potentially very broad extension of this topic, I refer to the written paper for more details. And during this presentation, I'm going just to propose some minimal reflections on just two possible tools currently widely discussed at the European level for the contrast of in-work poverty. There are adequate minimum wages and guaranteed minimum incomes. So about the first, on minimum wages, leaving aside an analysis of contents and prospects of implementation of the proposed directive on adequate minimum wages, it's just crucial to understand if it may apply to self-employed and how. And on this point, actually, the proposal shows lights and shadows. As for the lights, we may see that in paragraph 17 of the preamble, it is stated the opportunity to include in the scope of this directive a series of non-standard workers, such as platform, intermittent, voucher-based workers, and bogus self-employed, but just as long as they fulfill the criteria established by the Court of Justice for determining the status of a worker. So from this perspective, it should be observed that this list of non-standard workers mentioned in the proposal, and recalling the definition already contained in the directive on transparent and predictable working conditions, may allow the inclusion in the scope in the future of a relevant portion of self-employed that could be defined as not independent. As for the shadows, this notion continues to push the economically dependent self-employed within the notion of genuine self-employment and outside of the protective umbrella on minimum wages. And it should be said instead that a teleological interpretation of minimum wage guarantees should require, per se, the application of minimum wage floors to whoever does not have control over the price of his business transactions, and especially considering the express anti-poverty inspiration of the directive proposal. But in any case, beyond the intrinsic limitations of the directive is the possibility of a purposive interpretation of the scope of this proposal and of labor protections that could emerge from this preamble. Deserves to be emphasized, verifying if the notion of worker, so far urged by CHU case law, might be further extended beyond false self-employed, and following an expansive trend already plainly admitted for other areas of European social law, namely for anti-discrimination law. I don't know if you still can see me or hear me.
Yes, we can see you and we can hear you, and I'm just passing the slides. So you are now in the regulatory option, decent minimum income schemes.
Okay. In any case, if adequate minimum wages may be a viable option for low-paid autonomous workers, this may not be the case for low-intensity autonomous workers. And on this point, beyond the necessity to provide for ad hoc social protection measures, on which I think the following presentation will focus, the following presentations, the introduction of minimum income schemes may be necessary to complement the protection granted by minimum wages, and for the hypothesis in which one is not eligible for social insurance payments, even if I'm aware that minimum income schemes are addressed to poverty in general and not specifically to in-work poverty. And lately on this point, the Parliament exhorted the Commission to present a new framework on minimum income, formulating this invitation significantly on a resolution on reducing inequalities with a special focus on in-work poverty, and a resolution in which the issue of the rising number of self-employed working poor is clearly underlined. Anyway, this indication are destined to stay confined to the limbo of good intentions if not followed by binding regulatory interventions, such as a framework directive disciplining common rules and principles on a decent European minimum income. But on this subject, it has to be reminded that until now, the idea of the lack of a supranational legislative competence has prevailed, in connection with the absence of harmonization powers in the provision expressly devoted to the fight against social exclusion. And lately, in its action plan on the European Pillar of Social Rights, the Commission referred again to a soft law instrument, it has a Council recommendation on minimum income to be adopted in 2022. However, there's no lack of proposal of alternative legal basis should political will on this point arise, and from this point of view, elements for the legitimacy of a framework directive minimum income can be found in a detailed legal opinion released by the European Anti-Poverty Network, in which is identified a dual legal basis composed by Article 153, paragraph 1, letter H, dealing with the persons excluded from the labour market, and Article 175 TFU on the strengthening of social and economic cohesion in the EU. Of course, I don't have time to deal extensively with this topic, on which we'll find further details in my paper. Anyway, even considering a framework directive on minimum income as one of the necessary tools for alleviating in-work poverty and for mitigating the disruptive effects of the pandemic, it has to be underlined that the
Veronica, we lost you. Lose you. We are still losing you.
She has disconnected from the room.
Yes, I guess so. I think we should rely on her last slide. Which concludes itself with a question. So it's an open question. If the collective voice for self-employed may be a solution. So if you read the paper, this is one of the possibility Veronica was envisaging in concluding her analysis. So unfortunately, she left, not voluntarily, I suppose. So I think the best is to pass the word to Olga Chesalina, and maybe we can resume the connection with Veronica later on. Please, Olga, the floor is yours, 10 minutes.
Good afternoon. Can you hear me?
Yes, perfectly.
Thank you. Okay. Could you please share my presentation? Okay. And we will move quickly to third slide. And the topic of the next slide. Thank you. The topic of my presentation is social protection of platform workers. And in my presentation, I will focus on the national approaches. And you can read my consideration concerning European approaches in my paper. And let me start with a quotation of Gay Standing. Every period of economic reconstruction associated with major technological change and the renewed pursuit of flexibility has eventually induced a counter movement to provide new systems of social protection comparable with new structures and processes. And traditionally, social protection is based on the binary distinction between dependent and independent work. And the reason for this categorical distinction is rooted in the 19th century and the time of industrializations. And now, nowadays, new forms of work brought about by the digitalization. And platform workers are still considered in many cases as self-employed, with the result that they are excluded from the social security schemes and lack access to social protection. And I will try to examine how the social protection of platform workers could be improved at the national level. Current social law, mostly in the developed countries, offers different solutions how to extend social protection to non-employees. And there are different reasons for introduce special regulations and schemes. The reasons are following: to reflect the need for social protection of these persons, to adapt social protection to the special employment situation, to tackle bogle self-employment, and finally to compensate for so-called double contribution issue faced by self-employed persons. And there are different solutions. The next slide, please. In social law, and we can distinguish between doctrinal solutions and political solutions. Doctrinal solutions are based on distinction, based on respective legal term, and the interpretation of this term can be flexible enough in order to cover new forms of employment like platform work by courts. And we can see it is the case in France or in Germany or in United Kingdom. And there are also a number of political solutions when the legislator can try to define new group of persons and to make them a part of the existing social security schemes. And there are different solutions beginning from inclusion into the social insurance schemes, or it's also very important solution is a treatment as employee. It is possible by introducing of a fictitious term of employee or by introduction of an insurance scheme. In short, is employee, for example, home workers is the case. It is also very known solution concerning introduction of new intermediary employment categories. Other solution is the creation of special insurance scheme for a separate group of self-employed, and the German social security scheme for artists is a widely cited example. And finally, it is also possible to provide social rights in civil contracts. Nevertheless, there are different limits of such solutions. The next slide. In some countries, the recognition of special status is linked to some special formal requirements, and the fulfillment of these requirements depends on third persons. There are also problems with the introduction of intermediary category, because it can cause misclassification problems, or it can contribute to the circumvention of the existing employee category, and so on. Nevertheless, while labor law in many countries is still designed for employees, social law seems to react more quickly and flexibly to the changes in the labor market in order to overcome the all or nothing approach, binary division between employees and self-employed, and to guarantee social protection of persons who fall outside of the scope of labor law regulations. In other words, it is possible to disconnect social protection from the employment status. Let me come back to platform workers. The common outcome of the different empirical studies on platform work is evidence of low level of access to social protection of workers on demand, especially those for whom it is a main job. And some countries have already realized some new innovative solutions in order to address the need of platform workers in social protection. And I would like to take the opportunity to present our new publication on this place, where you can find 9 country reports and 5 general reports concerning new innovative ways of ensuring and financing social security in the digital age. And now I would like only shortly mention 2 examples of innovative solution. One solution is arrangement of umbrella companies in Sweden, and Anne-Marie Westergaard is expert in this issue, and I would like only to explain the sense of this construction. In exchange for a fee, umbrella companies take care of social security contribution and payroll taxes of self-employed persons, and in this way the self-employed contractors are covered by the general public social protection system as employees during their assignment by the client. And the next example is the smart arrangement for delivery riders in Belgium. It was active only during 2016 and 2017, and the result was the delivery riders were also protected as employees. We can see on these 2 examples that, like classical strategies for extending the access to social protection to non-employees, the new strategies are aimed at finding, firstly, a person or institution compatible to an employer, fictitious employer, who can take over social protection and social insurance obligation on the one hand, and treating self-employed persons as employees for social security purposes on the other. And concluding, I would like to say, on the one hand, classical solutions to extend the social security scheme for employees to self-employed is still highly relevant. Furthermore, many scholars favor classifying platform workers as home workers. But on the other hand, it has to be kept in mind that in many countries, the regulations concerning labor and social protection, for example, of employee-like persons, were introduced already in the 1970s, when completely different labor market patterns dominated than today. And also the characteristic of dependence, of economic dependence, have changed, not only in the case of platform work, but more broadly. And for example, it is not more typical to work only for one client. When we can see these schemes, for example, social protection of home workers or social protections of intermediary categories of employee-like persons, we can see that there are still dependents that dependent self-employed get contracts only from one client. And some countries, for example, Portugal, try to overcome this approach, but these examples are quite rare. Heterogeneity of platform workers, platform work and platforms, different strategies in terms of allocation of tasks, differences with regard to whom a platform worker is dependent upon, a platform provider or a client, and also new features of dependence, all require more flexible and fine-tuned solutions. And the challenge of social protection of platform workers shows also a lot of similarities to the broader and older problem of providing social protection to non-standard workers, bogus self-employed, and essential limit also of some innovative construction, for example, that platform workers are not protected between assignments. And the same limit is characteristic for on-call workers, 0 hours workers. And sustainable solution is to be found not only in a special regulation for platform workers, but also for all persons in the gray area between dependent employment and self-employment. And finally, the reason for imposing a duty to pay social contributions and for taking over financial responsibility in general on companies, principals, clients, or platform operators should be based on the recognition of a broader category of economic and social dependence of contractors, home workers, or platform workers. And if social security obligations are imposed only on platform operators and not on other actors like clients, principals, customers, they might turn to new business models and constructions which allows them to avoid social obligations. Thank you very much for your attention.
Thank you, Olga. You're just 2 minutes late, so it's perfect. Very quickly, I will pass the floor to Maria Cristina Degoli. Please, Maria Cristina.
Yes, thank you very much. So I'm trying to share this slide.
The presentation is there.
Okay, so you see the presentation because I'm not seeing.
Yes.
Oh, perfect. It is there. Okay, thank you very much. So, recap the title. Okay. Let me briefly introduce myself. I'm Maria Cristina Degoli, and I'm a postdoctoral researcher at the University of Louvain in Belgium. And the title of the presentation that I'm going to start is Flying to Neverland, where flexible social protection supports self-employment. As you easily catching, I'm referring to the magical island, so the Neverland, where the bunch of lost boys enjoy terrific adventures, despite the fact that sometimes they have to fight pirates. But it's another story. So my presentation will focus on this idea because I'd like to invite you to approach the concept of both the employment and social security from a wider perspective, so not stuck into the classical ones, we can say. As you can see from the agenda, the presentation will be divided into 3 parts. The first devoted to the dynamics of full employment and describing this concept of full employment from a wider perspective. I would like to lead you to flexible architecture of a social protection able to cover, in my opinion, the transition in the labor market. Then I will give you some remarks to conclude the presentation. So, starting from the dynamics of full employment. If we think about the classical concept, the idea that pop-ups in our mind is related to the a stable job, a full-time, permanent job from which the worker and their families are entitled to receive social protection. And if we stay in this concept, in this traditional concept, we can lose the opportunity to go a little bit beyond of this. So I would like to present you some ideas coming from theoretical approach that have been presented by Alain Soupiot, the professor Alain Soupiot, from the social security framework, and from the economic professor Bernard Gazier and Gunther Schmidt. And I'm referring to the transitional market labor market. And if we refers to a wider perspective of full employment, we can introduce the labor force membership status that has been conceived by Professor Soupiot and his international group of researchers. And the novelty of this approach is putting at the center of the protection the individual, the worker. So the protection are not linked to the employment relationships, but are linked to the individual. And around this individual, I've been able, the professor and his researcher have been able to design 4 circles in which the individual can find the protection of some rights. Starting from the first cycle, so universal social rights, we refer to the rights that are guaranteed to everyone without taking into consideration their job. The second cycle is the rights based of an unpaid work. Then the third refers to the common law occupational activity, and finally, the first cycle covers the law relating to paid employment, which contains provisions directly connected with subordination only and provides for a scale of rights related to the degree of subordination. If we move to the from the legal framework to the economical perspective, we can easily understand the meaning of the transitional labor markets of this theory. This theory is focused on transitions. So the key word in this theory is transition. So the protection is not linked only to the employment relationship of the worker, but the aim is to cover the entire working path of the worker itself. So starting from the first activities over the entire career, the working career. So every transition is important, every transition counts in this theory. So the transition has been described as any sequence in career leading to a change from a stable position to another one. From this perspective, the protection is covered all over the journey, the working journey of the worker, and these transitions are could be seen as a choice, could be seen as a freedom to take it, and not just something that you support from the dynamic and the flexible dimension that is now occurring in the labor market. So thanks to this new concept, it's possible to give security not only related to a stable job, but all over the career of the worker. The idea to structure, to reshape the social security scheme came from a comparison between the European labor market and the internal labor market. So when we think about how it is possible to imagine a flexible structure in social security, it's possible to catch some advice from the European labor market, where the treaty are announced and are supporting the mobility of workers. So if we think about the transition, and we would like to compare transition in something that we already know as a legal framework, we can refer to the mobility of workers. Article 45 relates to the freedom to workers to move between the union area and be able to looking for a new job, new opportunity without facing discrimination problem, because there are directives that the aim is abolish them. Thank you. If you compare and the two sides, the differences in the national social security system that have been obstacle in doing this mobility could be the same at the internal side, internal level of the market. So it's possible to use the aggregation of contributions that are collected during the period abroad or in other member states to bypass, to go behind the internal problematic of the standard protection schemes. So to conclude, standard social security schemes do not fit anymore with the new organizational structure because of their lack of flexibility. Let me give you an example. It is as a shadow on a wall, and the shadow gets stuck, unable to follow the movement of the body from which originates. It means that the standard scheme are not able to move, to be flexible as the flexibility in the market and the employment relationship that it involves. For this reason, to try to avoid pension poverty, if you think about the social protection of the elderly, it could be possible to design, to reshape a flexible scheme in protection, implementing the contribution aggregation for the internal labor market that we have experienced so far in the European labor market. Thank you very much.
Thank you, Maria Cristina. You are perfectly on time. And now I will immediately give the floor to Leonardo Battista, University of Bologna.
Yes. Okay, I will try to share my slides, but I think that are already here. Okay. Can you see my slides?
No. Yes.
Okay. First of all, thanks for being digitally here. And as you can read from the first slide, my paper deals with the social security for self-employed workers. But I decided to look at this topic from an opposing perspective, the one of universalism and selectivism. When we talk about universalism in social security, we talk about the possibility of grants, entitlements, and rights to the entire population. If we talk about citizens or the entire workforce, if we look about the workers. This approach that is normally applied in social security in many countries has its opposing approach, that is the one of selectivism, where services and entitlements are granted and provided to a specific group of people or on a specific need. In order to understand this opposition, that in my opinion could be linked together, I decided to look at the European level if there is a universalistic tendency in the EU acts towards the full coverage in the field of social security for self-employed workers. Then, of course, one of the other research questions was the EU competencies in this field, and then arriving with a de jure condendo solution about the mid-spectrum directive. Okay. As we listen from my colleagues, self-employment and social security is one of the tough topic when we talk about autonomous workers. Normally, social and traditionally, social security systems are designed on the subordinate worker, so they face several problems in adapting to self-employment. We can talk about the problem of heterogeneity in needs and priorities, or the difficulties in have incomes and the possibility to pay contribution in a strict way. All of this problem creates several problems if we look at the possibility to extend provision, or if we look at the problem of the effective coverage. And if we keep in mind this problem, the effective coverage, we can see that the European Union in the recent years deals a lot with this kind of topic. When we talk about effective coverage, we mean the fact that there are many countries where self-employed can access to rights and entitlements, but have the difficulties in achieve the effective level of contribution or the requirements to access to a specific entitlement. And the problem of effective coverage was faced by the European Union and the European Commission into very important acts, even if they are soft law acts, that in my opinion create and give the possibility for European Union to create universalistic tendency towards the universalistic coverage of social security for self-employed workers. We're talking about European Pillar of Social Rights and the Council recommendation on access to social protection for workers and self-employed. In my opinion, they are a real and pivotal junction point. They try to stress the need for adequate social protection for all workers. So in this perspective, we can look, we can think about that specific and universalistic tendency. When we look at this tendency, as I said, we should keep in mind that both acts are soft law acts, so non-binding acts. However, they try to put under the spotlight the need for employed workers to have adequate social protection. This was the 12 principles, the main theme of the 12 principles of the European Pillar of Social Rights, where we can see that there was also the concept of under comparable conditions. Then, if we look at deriving acts deriving from the European Pillar of Social Rights, and I'm talking about the Council recommendation, we can think that it is the most universalistic act in this field, because we have a universalism in the principles that this kind of recommendation tries to achieve. In fact, the Article 3, the point 3, sorry, of this recommendation stress the need for adequate social protection for all workers and self-employed, giving also some specific inputs about the benefits that the member state should extend. For example, sickness, healthcare, paternity and maternity benefits, or accident at work provisions, even arriving to unemployment benefit. However, as I said, this universalistic attitude faces several problems. First of all, we are in a very tough context for the European Union, because there is a problem of competencies. According to the Article 153 of the TFEU, the European Union has only supporting and complementing competencies, and the social protection is in this under this level of competencies. Then on the other side, we've seen that there was a withdrawal from the negotiation when the European Commission tried, on the basis of the 12 principles of the European Pillar of Social Rights, to try to adopt or launch an initiative for a European directive in this field. We've seen a withdrawal from the negotiation made by Business Europe or CEP, against instead the position of ETUC that tried to support the adoption of a directive that could give adequate social protection for every worker. And then there is also the problem of the financing of this increased coverage that we've seen in the presentation of Professor Chesalina, the double contribution issue, for example. Then here the main point of my paper, this blurred situation. I think that we could find we should not waste the EU tendency towards universalism. In my opinion, there is the possibility to adopt a directive, even if on minimum requirements. Do you hear it the same? Okay, because I'm hearing a noise. I was saying there is the possibility to adopt a directive on minimum requirements, implementing the Article 153, second paragraph, letter B. However, this is applicable to social security and protection principle, but it needs a unanimous approval. So every member state has a veto power. What is at the basis of my proposal is the minimum requirements. So when we talk about the minimum requirements, we talk about a minimum level playing field in the field of social security for every workers. And according to what you can read in my paper, EU may not adopt the minimum of all existing protection standards, but can fix and set its own minimum requirement, giving also the possibility for countries and member states that are not already in line with this kind of level of protection to integrate and implement their social security systems. However, every country has the possibility to provide a more stringent level of protection than EU law, because this is not an harmonization directive. Well, in case of an agreement, the achievement of a minimum level playing field in terms of social security could be very beneficial for self-employed workers, even in countries where they are not covered. There are some obstacles. As I said before, there is a veto power, so the European Union should play the role of a mediator. Then there should be a political negotiation on the material scope of this possible directive. And we've seen that there were many problems with the social partners when they talked about the possibility for a directive. And the problems were related to unemployment benefits for self-employed workers. And I think that the mid-spectrum solution could be could be reached, because on the top of this minimum, if there is the adoption of this kind of directive, member states and social partners have the possibility and should be able to focus on selective measures for selective groups of self-employed workers, so targeting only specific group of self-employed workers. We have seen with gig workers in many countries, or we can recall the next year initiative that the European Commission wants to launch about the possibility to grant collective rights for solo self-employed. So there is already at the European Union and in member states the focus on selective measures for selective targets. So in order to conclude, in my opinion, this universalistic tendency that I found at EU level should not be wasted, and upon the implementation of a minimum requirement directive that, in my opinion, is very tough, there is the possibility to increase social security for self-employed workers, adapting and implementing also selective approach and selective measures at national level. Thanks for your attention. And I hope that I remained in my time.
Yes, couple of minutes, but it's okay. Thank you, Leonardo. Thank you very much. So now I would like to call back Veronica. Veronica, can you hear me?
Yes, can you both hear me and see me?
Yes, it's all right. So you have two minutes for your conclusions.
Yes, I couldn't be more sorry than this, believe me.
No problem. May happen.
I'm not sure if I already talked about minimum income. Maybe yes, but okay. Yes, in any case, if I was talking about minimum wages when the connection fell down, I think. So if adequate minimum wages may be a viable option for low-paid autonomous workers, this might not be the case for low-intensity autonomous workers. And on this point, beyond the necessity to provide for ad hoc social protection measures, the introduction of minimum income schemes may be necessary to complement the protection granted by minimum wages, and for the hypothesis in which one is not eligible for social insurance payments. I am aware that minimum income schemes are addressed to poverty in general and not specifically to in-work poverty, but anyway, they could be used as a last safety net for self-employed that are in a situation of in-work poverty. And lately, the Parliament exhorted the Commission to present a new framework on minimum income in the context of a resolution focused on in-work poverty, and a resolution in which the issue of the rising number of self-employed working poor was clearly underlined. Anyway, these indications may be destined to remain confined to the limbo of good intentions if they are not followed by binding regulatory interventions, including a framework directive disciplining common rules and principles on a decent European minimum income. But I am aware that on this subject, until now, the idea of the lack of a supranational legislative competence has prevailed, in connection with the absence of harmonization powers in the provision expressly devoted to the fight against social exclusion. And again, lately, in its action plan on the European Pillar of Social Rights, the Commission referred to a soft law instrument talking about a Council recommendation on minimum income to be adopted in 2022. But however, should the political will arise on this point, there is no lack of proposals on alternative legal basis. And from this perspective, elements for the legitimacy of a framework directive on minimum income can be found in a legal opinion released by the European Anti-Poverty Network, in which is identified a dual legal basis composed by Article 153, paragraph 1, letter H on the integration of persons excluded from the labor market, and 175 on the strengthening of social and economic cohesion in the Union. Of course, I don't have time to deal with this extensively in this occasion, so I refer to the written paper. And anyway, even considering a framework directive on minimum income as one of the necessary tools for alleviating work poverty and for mitigating the disruptive effects of the pandemic, it has to be underlined that the recourse to minimum income schemes for self-employed should be intended as a last safety net. And of course, as a second best strategy in comparison with the investments in the creation of quality jobs. So of course, just to be particularly clear, I'm not proposing minimum income schemes as a functional substitute for decent wages and jobs. As a provisional conclusion, should be pointed out that in front of the multidimensional nature of in-work poverty, minimum wage or minimum income tools could hardly work as a self-sufficient ways out of poverty, and a credible strategy on this point can only derive from an integrated system for combating in-work poverty, for which I refer again to the paper. And just as a last remark, it could be said that in such an integrated system, there should be space for collective voice for self-employed, and recently in June 2020, the Commission launched a process to address the issue of collective bargaining for self-employed, apparently starting to walk on the path that may lead to the overcoming of competition law restrictions in this field. And this is a path that deserves to be encouraged and attentively followed. That's it this time. Okay. Thank you very much for your attention. Again, I apologize for earlier. Thanks.
Thank you, Veronica. Unfortunately, these kind of meetings, they have always some problems, some technical problems and connection problems. Thank you very much. It was very interesting. Of course, you had to cut and to synthesize your positions. I will try to give some comments before we start the discussion. In any case, if there are any explicative questions, so if anybody from the audience, before I start my comments, would like to address for some explanation the four panelists, please go ahead. For remarks and comments, we have the debate, but if something is not clear as such, can be asked. I have a question to to Veronica.
Yes.
Could you please elaborate a bit on the notion of low-intensity workers, autonomous, self-employed? This low intensity, what do you mean?
Yeah, it's some kind, it's linked to the notion of in-work poverty, actually, that I didn't explain this occasion. But in-work poverty is a relative notion, and it is mainly grounded on the family, the household unit. So if maybe it's more probable that a worker is working poor, is in a situation of in-work poverty, not just when his wage is low, when he's a low-paid worker, but when the intensity of work of the household is low. So I was just referring to low-intensity households and worker belonging to low-intensity households. I mean, it was very difficult to explain in broad terms, but it was linked to the notion of in-work poverty. There is mainly household notion, not just an individual one. So in-work poverty is mostly linked to the intensity of work in the household. So I don't know if it's
Yes,
now
it's perfectly clear, and I think also for the audience
I was
was
referring to this kind
important.
of low work intensity with reference to the household and also to the discontinuity of work. So
Okay, thank you very much. So I would try to make some general remarks. You all more or less highlighted a first problem, which is that one of the heterogeneity of self-employment, and the fact that maybe like employment is difficult to really grasp the very notion of self-employed as a group, if it's possible, because I have my doubts that is it really possible to understand self-employment as a phenomenon that can be classified as such. So maybe is easier to have a comprehensive notion of employment than to have a comprehensive notion of self-employment. But on the other hand, you all refer to the fact that there is a link or also similarity between self-employment and atypical works or atypical employment. So the fact that in the light of social protection, we could say that the problems of self-employment are comparable, if not the same, of the problems the social protection system encounter when they are called to protect atypical workers, or so atypical employees. One could say, even if in your papers also this distinction is very much blurred, in the sense that maybe there is no conceptualization, but you all feel that there is something wrong in saying that there is a clear difference between atypical employees and self-employed. So the gray zone is even grayer and grayer, in the sense that when it comes to social protection, maybe is even more difficult than when we talk about labor law or, of course, regulation of working conditions. This thing is a point that pops up from your presentation, and I think it's a point worth to be investigated, because the social protection, the uncertain social protection of atypical workers, atypical employees, could be an interesting key, an interesting heuristic tool also to understand the position of self-employed in the social protection perspective. Of course, this has been, if possible, make even more complicated by the reflection on platform workers, because there, I think the same notion of employment or self-employment is likely not to be really effective in classifying the platform workers. So I think that digitalization is increasing our difficulties in providing social protection if we start from the dichotomy or this kind of binary division, as Olga defined it. In my view, the metaphor that Maria Cristina used of Peter Pan with a shadow is a very not only catching, it's very catching, but it's also effective because the risk we have is that we try to attach the wrong shadow to the wrong person. The Italian legal system is experiencing it very clearly with the so-called hetero-organized collaboration. So that we just say, well, the protective statute of employees applied to this kind of person, this kind of workers. So maybe one point that could be interesting to analyze is not necessarily the specificity of needs, because as I presented, maybe the needs are the same. If you fall within a certain economic or social or legal condition, the needs are more or less the same, but the problem is maybe the specificity of benefits. Because when we put the wrong shadow, when we attach the wrong shadow, then we just pass the benefits to the person involved. So it's like a package, and the package deal is not always the best solution, because then you lose the specificity. The specificity which is not necessarily linked to the juridical qualification of the work relationship, but maybe the specificity of the economic and social condition of people who are in between, in the gray zone. And so in my view, and that was also my conclusion in the chapter in the book Olga quoted, in my view, the point is that we should investigate more really in details what kind of need and what kind of benefits these different groups or each person really claim for, because otherwise we can fall in various traps. So we can get trapped. You can get trapped in solutions which are not effective for the person in need. And there, of course, one could also check whether all these people have the same needs, and all these different forms of employment, self-employment, should enjoy the same protection. But from this point of view, I think that the investigation should, for a moment, just for a moment, forget or put aside the existing models. So this is a kind of theoretical but also empirical reflection. So the point is to look at the person and to look at a shadow the person is projected, not to presume that all the people will project the same shadow. Of course, then we fall, or we meet the idea of Leonardo, universalism and selectivism. It is clear that universalism can be very effective when it comes to the minimum level. I totally agree with you, Leonardo. But and the minimum level is, of course, at least something. So if we are, if you have low expectation, we can be, of course, okay with the minimum level. But on the other hand, the minimum level has also the risk of standardizing different positions. So of course the floor of rights is a very positive solution, but if then there is something on the top. So on top of the floor of rights, so even if we reach a minimum level of floor rights, then I think we will be once again confronted with specificities. And then we have to decide whether these specificities and the differences have to be taken into account by a public scheme, or if, for instance, the solution is just professional or occupational schemes. So that the floor of rights is just the public protection, and then the differentiation is up to the categories. But then you need, and this is an interesting point you made, and you need also a kind of self-consciousness of the groups. So the point that the people should identify themselves in a group in order to develop, in order to introduce an occupational social protection, because otherwise you will be totally lost. And this is, I think, an important element to be taken into account when it comes to the floor of rights or to the universalistic approach. And also to the fact that this complementary social protection, should it be mandatory or free? So what is the attitude of society, public authorities, the legislators towards this kind of complement? And this, I think, and the minimum level, the floor of rights approach as a further problem, and you all have highlighted it, the fact that it should be necessarily supranational. Because if you fall in a national legislation, then the floor of rights is very relative. And on top of that, of course, we have huge problems in protecting the needs, for instance, of platform workers. Because if the principle of territoriality does not apply to platform workers, then they are in a way alien or without any kind of protection. So I really appreciate the fact that you all tried, in any case, to underline the need for supranational, international, common perspective and a common view. I will stop here, even if I would have some remarks on the juridical basis, but I am running out of time, so I will stop and give the floor to our audience, to the participants. You can raise your hand or write on the chat. Barbara Grandi, we have a, please.
Can you hear me now?
Yes.
It's been raised, the matter of the so-called double contribution in a couple of the relations that you presented. And I was wondering whether you consider such an issue as problematic, apart from the fact that, of course, it is problematic. It could be problematic to technically sum up the contributions that any single worker might have paid to different social security systems. So what kind of what is the problematic issue that you was underlying with that point?
Okay. So anybody wants to react? Barbara, could you please close the mic? So, okay. Unmute.
I would like to answer this question. Can you hear me?
Yeah, please.
The double contribution issue means that self-employed have to pay social contributions alone, while in the case of employees, the social contributions are divided between employer and employee. And in case of self-employed, especially if they carry out activities or provide services for other persons, individual or organizations, we have to find a person who are responsible for their social protection. And sometimes it is very difficult. There are different ways how to find this person. For example of home workers. In this case, it is very easy to find contractor who will be responsible for social contributions. However, also in this case, we can have problems because practical enforcement problems, because not all contractors are ready to pay these contributions. And for example, somebody who is IT specialist or freelancer, they probably do not know that they're home workers, and their contractor can just ignore their duty to pay social contributions. The other problem with this double contribution issue is that one client, we have only, almost in all countries, the situation is that only if we have one client, if we have intermediary category like Trade in Spain or freelancer in Norway or Coca-Cola in Italy, we have to find one client for whom is predominantly is provided carried out activities. And if we have network organization, if we have a lot of clients, it would be difficult to find one client for whom is predominantly provided activities. And only Portugal tried to overcome this approach and has lowered the criteria of access to the unemployment insurance scheme. Instead of 80% dependence upon a single contracting entity, now suffice only 50%. But it is very, very rare case. Furthermore, the legislator tries also to solve double contribution issue in another way, probably to provide for a reduced contribution rate in comparison with the usual employees' share for self-employed, or subsidized insurance contributions, for example, in case of new self-employed or other self-employed, or in case of agriculture for farmers and so on. Or it is also possible, it also connected with the problem informal employment, just to introduce tax and social contribution holidays, or to exempt them from the payment of social contribution. However, in this case can arise other problems of substitution this form of employment upon other, for example, employee or other form.
Okay, Okay, thank you very much, Olga. Any further questions, remarks on our presentations? I have one in the chat. Let me see. No, it's all right. Okay, so I would like to come back on the issue of the juridical basis. So I would like to call at least Leonardo, Maria Cristina, and Veronica, if she is here. Because I'm, yeah, you are here. Okay. Because I have the impression that that you have doubts on the availability of a juridical basis at EU level, which fits the purpose of protecting self-employed from your different points of view. Am I right, or I just misunderstood? Of course, Olga, you too, you can tell us something. If anybody would like to, yes, Leonardo.
Yeah, okay. Well, as I stressed in my paper, there is a possibility for implementing social security for self-employed workers. However, it's quite hard to reach unanimous approval according to Article 153. So, in my opinion, there is the possibility, but I'm not very confident in its approval. Then there are also other problems that are not political one. The fact that if we adopt a minimum requirements directive or a directive on minimum requirements, we should not affect in a significant way the financial and situation of the member state or the financial social security schemes. So, in my opinion, there are many obstacles that the EU level in this field should overcome. So I'm quite sure that there is the possibility, but there are also many obstacles for an implementation right now.
So the first point is a political point, but this was the whole discussion on the harmonization of national social security system. But you also pointing out that there is a problem to the extent that this minimum level will affect the financial and the systemic situation of social security system. So this is, of course, maybe a most important and effective problem than the political will. Any other opinion on this? Yeah, please.
Just something I was wondering about the legal basis of a possible directive on minimum income, about dealing with minimum income. But the problem is that the legal basis individually considered, legal basis contained in Article 153 may encounter many problems, unanimity or other kind of problems regarding the scope. So as just proposing a dual legal basis, as happened in a recent legal opinion released by the Anti-Poverty Network, grounded on Article 153 and 175 on social and economic cohesion, just to complement them and to overcome the problem of unanimity, and to extend the scope beyond just persons excluded from the labor market or just worker, as in the legal base under 153 letter C. So just proposing dual legal basis, because if you use just Article 153, you may encounter the problem of unanimity, or the problem of selecting the personal scope in a way that cannot comprehend all persons in all stages of life, as requested by Principle 14 of the European Pillar of Social Rights. So for this reason, I was just recalling the idea of a dual legal basis to complement this possibility of overcoming unanimity and also extending the scope to all possible persons in need in every stage of their lives.
Okay, this is interesting, and I think we should, as labor and social security lawyers, we should refer more and in a more convinced way to Article 175. I recalled it talking about or writing about the transnational collective bargaining, but in my view, the idea of social cohesion has to be focused if we want to avoid, as you said, the constraints of the social policy title, because there, of course, there are many constraints, and maybe the fact that we are thinking about a minimum level would correspond more to the idea of social cohesion than to the idea of social protection as understood under the social policy title. So this is also an interesting point. Any other comment, Maria Cristina or Olga?
Sorry, Professor.
Okay.
I was disconnected, so sorry if I didn't intervene in these 5 minutes, sorry.
Okay, no, any comments on the juridical basis? The fact that
I would like just to give some comments related to maybe to give more details about the presentation and the legal framework. So I was referring in my presentation about the chance that the aggregation of contributions during the period that workers spend in working in other countries could be a good measure to try to protect better self-employed and atypical workers in their working life, because it gives us the example how it's possible as a legal framework to go behind the employment relationships to link some protections. And in this case, if I present as an example the pension issue, it could be the chance to reshape the architecture of the standard scheme and let workers could be able to enjoy the collection of the contribution all over their working period, and not without having troubles in reach the criteria as a vesting time, vesting period that are maybe they could be required at the internal labor market, so at the national level, from the legal framework related to the chance to secure the self-employed.
Okay, thank you. So if there is no further question or remarks, we are perfectly on time, 2 minutes ahead of schedule. So I would like to thank all the panelists. I think they provide us with a very valuable contribution in order to understand the issues of social protection of self-employed, but also to envisage some solutions that could be adopted in a more or less effective way. Of course, this is then a matter of political choice at EU level or whatever level, national or international. Okay, so we now have a break, and the sixth workshop will begin at 6 o'clock, of course. And just for if there are any students of mine, because I invited also my students, we can meet in my room on WebEx. This is a communication to the students. Thank you very much.